and the discovery. So basically what was supposed to happen was once the judge says, hey, you can do discovery, then you're allowed to start collecting information. Because basically, WFG is trying to figure out what's going on, right? They haven't been privy to a lot of the communications that are going on outside. So what they're asking for is, hey, we want phone records, or text messages, stuff that's on social media, the different applications that the team uses, that kind of stuff, what was said, and all of that. So they've been trying to collect that, something like, I don't know, I think it was over 90,000 text messages since September and something like 75,000 emails since September. That's a ton. I don't know if you guys feel like that's a lot. That seems like a lot, but also I guess if you have what does he say, 20,000 or 10,000 people on his team, I don't know. I guess that's a lot of communication that's got to go out to maintain something like that as well. So who knows? That's possible as well. So, but basically they were giving a bunch of excuses on why they were not going to give up the information. So they're objecting to things like, they're saying, hey, well, we got terminated on January 25th, so why do you need the communication of anything before that? We'll give it to you for after, but not for before. And it's like, well, there were 3-4 months of recruiting WFG agents or you planning these types of things long before it actually happened in January. So we would like to know some of the communications that happened there. And so they're trying to attempt to get some of those things. We'll do we're going to kind of run through this fairly quickly because it's kind of a repeat. We've gone through it a couple times. But if you're newer and you don't really know what's going on and you kind of want to get caught up, we'll do that fairly quickly on kind of the introduction, what's going on and how we got to this point. Through the table of contents, there's going to be a bunch of case law that they're going to kind of go through. So the introduction, this is going to be WFG's effort. So this is Olson's response on why he's doing what he's doing. And so he's kind of making this case that, he's been with them for 20 years. He built this business that's $200 million and more than 20,000 agents whom he's recruited and trained. And what happened was WFG stopped him when he wanted to leave. This is what he's saying. This is his claim. So in this attempt to stop him, he first tried to transfer the business to his wife under the Heritage Program. So under the Heritage Program, you can transfer your ownership to somebody else. But when he told WFG of his plan, WFG told him its spousal transfer program was canceled. So basically, they wouldn't allow him to do it. Mr. Olson then sought to sell his business, as many of his predecessors has done, but Mr. Olson was told WFG of his plan. WFG claimed to eliminate that program too. After it became clear that Mr. Olson would not stay under any conditions, WFG fired him. And the people who fired him took over his income stream. Now, this is kind of in contrast to what WFG says. WFG says, well, they don't disagree with stopping the Heritage Program, but their side of it is that, well, we didn't really know what his plans were. And if you understand the anchor leg strategy, a lot of what Olson had used and his team had used of moving people over. And so when Eric actually got terminated for cause, and there's also a video about that if you want to read that, what happened was they caught him kind of on both sides, right? Or not just him, I guess, necessarily, but there were other people who were doing the exchange or the anchor leg strategy where one spouse was on one side, the other spouse was on the other side, and then they're moving people over in between, moving clients and agents over. And so that's when he got terminated. And WFG says that it's for cause because you're not allowed to do that. Along with the disparaging statements that he made, the claims that he had made, the testimonies that we had seen of Thali going over, and all these other things that were happening that haven't really happened. And Eric Carter reached out to me, and he's like, well, do you think this whole thing was started as a big lie? And I was like, no, I don't think so. But, there were a lot of lies that were told in this process. And unfortunately, people get caught up in between, right? And if you're making a decision about your livelihood and you make income on one side and then you move to the other side, or you do something it's really not legal to do the anchor leg strategy if you get caught doing that. If you're moving clients and stuff over, you can get into a lot of trouble for that stuff. So I think that the challenge with maybe the whole thing wasn't started on a lie. Maybe Olson had great intent in the beginning to go start a new company and he wanted to do it better. I could see that happening. but then you kind of maybe get caught up in the moment a little bit and you tell some things that aren't necessarily true, and then people make decisions based off of that, and now their livelihood is at risk. They're subject to lawsuits and everything else. So and I asked him too, look, if you have evidence that Dolly's coming over, or the things that Olson and other people have repeatedly said over and over again, if you have proof of any of those things, send it to me. I'll post it. I try to be unbiased. I try to just read between the lines of what I can see here. But that nobody's sent me any information of anything that's being said that's actually accurate. So anyway, shortly there, but he's saying that they're doing it purely kind of for the income. And I don't think that's entirely accurate. I think there were other conversations that were happening, and maybe the conversations were around him wanting to move all of his people to the new company. I don't know. Obviously, I wasn't there. I'm speculating on that. But there's stuff that's missing that we don't know about as far as conversations there. So anyway, shortly thereafter, WFG sued Mr. Olson and his wife. WFG then filed a motion for a TRO, which is a temporary restraining order, and which subsequently admitted, although not to the court, that he knew it would not succeed. I don't know why that's important, because the law is kind of interesting. It's almost like a sport as well. So sometimes you try things that may or may not be effective, but basically they're saying that the requests that WFG have propounded go far beyond addressing the issues the court noticed in its order, especially given the Hawaii conference has already passed, because they're asking for additional information. And so the temporary restraining order was not given because they keep citing the code. So if you haven't seen that video, there's another video on that as well. The allegations that WFG has, their legal standings, and then Olson's legal standings. He basically says, well, I can do whatever I want. I can say disparaging statements. I can recruit agents over. I can bring clients over, because in California, there's this code 16600, which is a non-solicitation clause, which is very different from a non-compete. Non-solicitation is very different from a non-compete clause. And so they keep trying to blur the line between these two things of a non-compete and a non-solicitation. Non-compete means you can't do anything in the industry. So if you have an insurance license and you have a non-compete, you can't sell insurance until that time frame's over. A non-solicitation is you cannot go after your old clients and your old agents. Very, very different, but they're trying to blur the line and say, well, if I can't recruit these people and bring my clients over, well, then I can't do business at all, which I don't know how good of a case that will have, especially considering GFI has non-solicitation clauses, even I think stronger than WFG's inside of it. So he's trying to say that it's illegal, that you can't use that, but then yet he uses it in his own company, which is kind of interesting. So basically he's saying that the temporary restraining order was denied because of that, and the court allowed limited expedited discovery to find out what was going on, but now they're saying, well, they're just going too far. And so all the Olson's devices are forensically imaged and preserved. They seek to turn the expedited discovery process into an oppressive fishing expedition. And when WFG has admitted to its own discovery responses that it does not have any evidence to support its claims. For information, for example, interrogatory 3 asks Olson to identify all communication statements made by you or persons affiliated with you or GFI concerning WFG. So again, they're asking, WFG is asking for all this information, right? Because they don't know a lot of the conversations that were said between Olson and other people, and all that goes into the court case about this process and what's happening. This has been everybody's kind of wanting to understand what's going on, because Olson could have simply just left WFG and started a new company, and there really isn't much that WFG or anybody else could have done or said about it, but it's the transfer of the agents and clients that are really kind of under question here. And so they're saying that asking for all of these things from all these other people isn't really fair. But I think it pertains to how everything happened, right? It gives the background of why these things happen and how they happen. And was there malintent behind it, or was it purely just Olson wanting to start a new company and create something better? Because all of that goes into this lawsuit and trying to figure out what exactly happened. And they're saying, well, you don't have any evidence of any of this stuff. And he's saying, well, it would encompass any statement Olson or his counsel made to 20,000 plus agents who fall within the sweeping definition of you, regardless of time or period, whether the statement had anything to do with the limited scope of discovery. So again, Olson's side is trying to argue that it's too broad. They're trying to get everything narrowed down, which I feel like WFG had. If you watch that other video, WFG was willing to tailor a lot of these things, right? They don't want information about you saying happy birthday to grandma and, happy anniversary to your wife. They don't need to know that information. They just want information pertaining to the case. But that's kind of their complaint here is they're like, well, how are we supposed to get information from 20,000 agents? And WFG's response to that was, well, we don't need the information from everybody else. We just want the information that you've sent to everybody else. So whatever you have out in hand is what we want. Despite the abusive nature of the request, this is why I couldn't do law. This stuff frustrates me. So on the request of Olson, immediately collected and imaged all the potential sources of the documents, sought to apply reasonable limitations so that he could actually comply with the request and begin meeting and conferring with WFG, a process that was still underway at the time that WFG filed its motion. In its motion, WFG complains that Mr. Olson has not produced a single document. So to this point, I don't remember exactly when that discovery was given, but it's been 2.5, 3 weeks. Basically, they were supposed to turn over stuff within 5 days. They haven't turned over anything to this point. But the statement is incomplete because it does not explain that WFG derailed the production by waiting 8 days until the close of the business day on Friday night, on the night that Mr. Olson was set to produce documents, to provide its comments to Mr. Olson's proposed stipulated protective order, which included a one-way AEO carve-out for WFG's favor to request that Mr. Olson run additional search terms beyond the broad term 25 terms, which include the term WFG. He has applied already. Mr. Olson agreed to do so at least to get a hit count by Monday. Therefore, this could occur. WFG filed the instant motion. So they're saying that WFG is the one that's kind of stalling. WFG is saying that they're the one that's stalling. So they're saying that it lacks merit. WFG seeks documents from the time that Mr. Olson worked at WFG, which are obviously directed to its underlying claims rather than any ongoing activity that can threaten irreparable harm. So they're disputing giving documents from before, because WFG said, well, we want to stop people from being recruited. And if you guys have been watching, there are over 7,000 agents was the last post. They can't help but share their stuff. So I think there are over 7,000 agents now. And so this is an ongoing thing, but they're saying, well, we don't need to turn over this information from before because it's not an ongoing activity. And every day I get, I wouldn't say every day, but every other day or so, people are like, hey, these people just left. Hey, we just had some more people leave. This is what's happening. They're going to GFI, whatever. So it is something that's still happening all the time. And so they're saying that it's not, and that's why it's not important to turn over that information. They also argue confidential information and forthcoming with document production. He explained that he would exclude anything he received from WFG after this termination or would look with him that could remotely fall within WFG's definition in its employment agreement. Okay, so they're going to talk a little bit about WFG. This is more from Olson's background, talking about WFG, that he has to recruit and he does his sales. WFG makes hundreds of millions of dollars, that he signed a contract. These are the clauses. So you're not supposed to take other agents. You're not supposed to solicit, induce, or entice in any other way or any other manner persuade or attempt to persuade any individual who is current WFG agent or whom the agent had business contact with on behalf of WFG or its affiliated or related entities to terminate or alter their agent relationship with WFG and join a compelling organization. So they're saying this is what he broke. WFG is saying that, and then provides that this agent will not use, disseminate, or reveal other information on behalf of WFG as an authorized WFG provider, confidential information, trade secrets, etc., etc. And all of the personally identifiable information, confidential and proprietary records, data information. So if you remember, they were doing basically like a hit list of agents. So they were going through kind of top performers. That way they knew who to focus on. If this guy doesn't come, well, I know who the top performer in his team is, so I can go target that guy to come over. So acquired and made disclosed to any agents or assistants the value. So basically they want all of their information back. Any personally identifiable information deems to be confidential by applicable state and federal commonwealth. So including the list of WFG agents and their identities and contact information. So Eric Olson, they talk about him building Pinnacle. This is kind of his history of building a company of over 20,000 agents. This is all still background. Olson leaves. So in October 2023, Olson informed WFG that she was terminating. She then shortly started GFI. WFG terminates Eric Olson and takes his multi-million-dollar business. So they offered him $20 million to stay. He refused on January 22nd. And once he received a letter from WFG claiming to fire him, that he violated his contract and legal obligations, he was terminated. Okay. They also started terminating agents who they suspected had some association with Mr. Olson. Mr. Renendez was terminated purportedly for violating restrictive covenants that he has defended Mr. Olson in a group chat. Mr. Welsh's wife was terminated for violating the same clauses because her husband was associated with GFI. These agents did not work at GFI prior to their termination. And as is traditionally done, WFG threatened its agents with lawsuits if they breached their restrictive covenants and encouraged others to share Mr. Olson have been terminated for cause. So this is where it gets convoluted, I think, in what they're saying, because they're saying, well, he wasn't officially at GFI working, right? And this is how Olson has been able to avoid, and Pinnacle, I guess I shouldn't just exclude Eric, but they've been able to avoid lawsuits because they say, well, that person's not working over there, but their spouse is. You see what I'm saying? And then one stays with WFG and moves the agents and the clients over to the other. But right here, they're saying, well, it's not fair. You terminated them for no reason. They were not working at GFI, even though they're moving stuff over to their spouse's code number. So you see how that's kind of deceptive? And they're like, well, they weren't working there. You just fired them because they know Mr. Olson and they supported him. And that's not true at all. They were sitting on the fence. One spouse is on one side, one spouse is on the other side. Very, very different from what they're saying here. They're not just threatening with lawsuits. They're saying, did you break your WFG contract? And if you do, then you're up for lawsuits. They're not just trying to sue people, at least from what I've seen. And if you guys have something else, tell me. But if they're breaking those contracts and they're bringing over agents and clients, well, then they're breaking their contract, which opens you up to lawsuits. Very, very different than them saying that they're purposefully like going after Eric's friends who didn't do anything wrong. They're still working at WFG the way they normally would. Very, very different from the accusations that he's kind of filing here. So Mr. Olson files concurrent and opposing actions. So on the 25th, they filed this action for a temporary restraining order. And the same day, Olson sued WFG in this district. They are, so there's two sides. One of them is Olson's side saying that, or WFG's side is saying that unfair competition law, tortious interference, conversion, breach of contract, and the covenant of good faith and fair dealings. And that's what Eric broke. And then on the other side, Eric's saying, well, that code in California, the 16600, says that you can't have a non-compete clause, so he's able to do basically whatever he wants. And so all of these are kind of pending and waiting for now. Days after filing the temporary restraining order, WFG's lawsuit against them is held. So basically they're waiting for everything to happen into California. So court denies WFG's motion for temporary restraining order. And I think this is important. I know it's kind of silly and we just walk through this, but your First Amendment is so important. I guess so is the Second Amendment. And there's probably a debate there on which one's more important because you can't really have the first without the second. But a temporary restraining order limits somebody's First Amendment rights. And so there's a very high level of standard that you have to be able to give somebody a temporary restraining order. They have to be doing some serious damage for that to happen, and obviously WFG didn't meet that standard. And what was interesting was there was a lot of, when that got declined, there was a lot of information coming from Pinnacle's team, like, oh, we won this court case, it's over. And it was like, no, not really. You just didn't get the temporary restraining order. That's very, very different. So just because you don't meet the standard of temporary restraining order doesn't mean that there is no case whatsoever. And so they're kind of just going through this time frame of that happening, and this is really kind of where we wanted to get into. So they're preparing for WFG's expedited discovery. So on the 28th, they were served a discovery request along with a protective order. Olson's began the process of collecting and preserving their electronically stored information. Even some of the previously deleted encrypted message on March 6th, within the ordered 5-day period, Mr. Olson provided responses and objects to WFG's request. So, see, he was already supposed to turn over all of the information, but on this day, he starts objecting to the discovery. He starts saying, well, they're asking for too much stuff, this falls outside of the bounds, whatever it might be. So on the 7th, the parties met to confer regarding to the objections that they have, this particular problem that Olson kept all of his WFG business materials on a Google Drive that contained many terabytes of data. The drive contained so much data that it finished being forensically imaged a few hours ago. Mr. Olson further explained that he had not accessed the drive since leaving WFG, did not know how to do so, and would not do so. In fact, it would be physically impossible while it was being imaged. So again, they're playing with these dates. They're saying, well, you know, I haven't accessed it since I left WFG, so that has nothing to do with what happened to it prior. So they're kind of playing a little bit of a game there. On March 7, Olson sent over a modified draft protective order reflecting the protections necessary for the case between competitors involves workers against whom WFG might retaliate. So I don't know, I don't think I've seen the protective order, but basically what they're saying is, and this can go too far either way. They can say, well, just because you find information on these drives about other people means that you shouldn't be able to go after them. And obviously that's not really fair to WFG, right? If they find that people were doing the anchor leg strategy through these messages and they're kind of double dipping on both sides, well, then they should be able to go after them, right? Because they were breaking their contract. It's not just because they're friends of Olson and they don't like them, it's because they were breaking their contract. So we are largely in agreement, but in hopes to streamline the sharing of these materials in specific related cases, the ability to share materials with experts. Also noted that he would be happy to discuss. So what we'll see happen here a bunch of times is they keep setting up meetings to talk about it. So on the 8th, they demand an update, close of business. Mr. Olson explained that his expedited collection and review efforts to date include collecting Mr. and Mrs. Olson's documents without any screening as to obtain the comprehensive universe of potentially responsive matters, right? Like, I'm not saying this is happening, but if they were having marital issues, right, and they're arguing about something, then obviously WFG doesn't need to know about that. So that protective order can kind of limit some of those things of what gets out. So it can be used for good, it can be used for bad, just like anything else. Our collection includes all forms of communications, including emails, text messages, and other messaging applications like Signal chats. We're collecting from phones, emails, and other cloud-based storages. We have been working and are as quickly as we can, and vendors to collect and upload all this data. So at that date, they had gotten over 350,000 emails from Eric and Sandra, and over 75,000 that were dated from September. So again, I don't know if that seems like a lot. You guys tell me, does that seem like a lot to you guys? On Sandra's phone alone, we have collected over 47,000 text messages from that same period. So September, October, November, December, January, February. I don't know if you would even call that March because it was March 8th, right? So 6 months, 47,000 text messages, 75,000 emails. That's a lot. And they expect to get the same from Eric's phone as well. The Signal and Telegram messages have not been uploaded yet. The encryption with these makes it a little bit longer, makes it take a little bit longer. And as we told yesterday, Olson's Google Drive at over 7 terabytes of it, that's like 14 computers, normal computers worth, right? If you have 500 gigs, it's like 14 computers. This is still a collection process. We don't know what is on the drive. And I don't know if that would necessarily be helpful. I don't know if I want to know what's on there, but it is what it is. So they're collecting all that stuff as well. So Mr. Olson represented that the correspondence he worked through the weekend revealed documents they were downloaded and made available. Olson uploaded WFG, finished collecting Mr. and Mrs. Signal and telegraph messages, adding another 44,000 text messages and chat message chains. So that's what, like 90 something thousand. These are some of the terms that they're looking for. And this yielded another 10,000 additional messages, emails, and messages from other applications. So they're kind of trying to limit some of the things. And the challenge that WFG was saying is, well, what happens if he text messaged somebody and didn't refer to any of these things, right? So if he didn't mention the word WFG in that message, but he was saying, disparaging things about the former company or practice company or whatever he used, they might not get that data. So you can limit it too much. WFG still has not responded to Mr. Olson's proposed protective order. So they're kind of using that as not being able to move forward. The parties met conferred again. So they met again on the 15th, prepared these documents, but WFG still not agreed to the protective order. WFG advised for the first time since Mr. Olson had sent its proposed protective order that it would not agree to a protective order that didn't include a carve-out from the California Standard order allowing their employees to review Mr. Olson's confidential information, and that it would send comments after the call. So they're disagreeing on that carve-out as far as the protective order goes, so it hasn't been able to move forward. On the same call, WFG also asked Olson to run additional search terms and documents, including GFI, but could otherwise identify the complete list of terms it sought. Mr. Olson agreed to run any proposed additional terms, even though the potential burden of additional review. Later on Friday, on the 15th, Olson had proposed modifications to the protective order, since Mr. Olson to please let us know if you would like to confer with this, and if so, when would be a convenient time. So they met again on Friday, list of 15 additional requests. So they're adding additional, WFG's adding additional request terms. On the 16th, Olson confirmed for a third time that the Olsons would produce communications relating to confidential information. On Monday afternoon, the 18th, they emailed the Olsons was going on forward with the motion to compel discovery on behalf of the plaintiff. The email did not identify any of the grounds on which WFG intended to move, nor did it request Mr. Olson's position for the proposed of a joint letter. 5 hours later, WFG filed the motion to shorten the time and respond to this motion. So WFG is saying, hey, we're still not getting any of this data. I think that's what it started around the 1st is what they said, right at the end of the February 28th. You don't really count that day. So maybe on the 1st or so. So it's been a couple weeks and they haven't gotten any of the data that they've asked for. But Olson is also saying, well, WFG hasn't provided any discovery to us. Some of you guys have asked what they were looking for, so hopefully we'll get some of that here. So on the 6th, WFG's agreement to provide reciprocal discovery, so they wanted some information as well, was required. Motion practice, Mr. Olson served 4 document requests and 4 interrogatories. Mr. Olson likewise requested responses and objections within 5 business days. On the 8th, it confirms that it will consent to limited early discovery related to WFG's request for injunctive relief. Will endeavor to provide written responses on or before the 15th. WFG did not provide written responses until March 28th, where it not only objected to each of Mr. Olson's requests, but also refused to provide any responsive information and documents related to his agents provided the declaration in support of the temporary restraining order. So that's what he's asking for. For those of you guys who are wondering, Olson wants information that pertains to the temporary restraining order. I don't know why this would be valuable for him, or if it's just kind of like, hey, I want something too. But maybe it gives him an idea of who was in support of the temporary restraining order and why they thought it was a good idea. Again, I don't understand really how that's helpful, other than maybe he can see some of the information that they have. I don't know if you guys have ideas on that, how that would be helpful, let me know. The party seeking to compel discovery has a burden of establishing that its request satisfies the relevancy requirements. They talk about some case law here, so the Olson should not be compelled to provide any additional discovery. The scope of the expedited discovery at issue should be driven by the court order and guaranteed by the fact that all parties cannot and should not be required to compact a whole year's worth of discovery into a few days. So they're saying they need more time. Which is kind of weird because they could have turned over something, right? And at least said like, oh, this is the point that we've gotten. Here's what we've gotten so far. But basically, they're saying that that has not happened thus far. So early Hawaii meeting has already occurred. The encrypted messages, which now have been captured and forensically preserved. Nonetheless, the Olsons have agreed to provide WFG a sweeping discovery regarding its claims. This discovery satisfies the Olsons' obligations and basically goes against WFG's motions for two different reasons, which is interesting. Can you, is it still complying to gather the information but not turn it over? I don't know. It's like we took a step in the right direction. We just haven't turned it over yet, but we have it. So that should be good enough, right? It's like, well, that's great, but I can't read it if you have it. Mr. Olson's responses are reasonable under the compressed circumstances at issue and intend to give WFG a robust discovery on its claims that the Olsons are currently improperly soliciting WFG agents to work for them and disparaging WFG. Mr. Olson even used the search words WFG to capture any communication by him or Olson or anyone from WFG about WFG in the prevalent period. Mr. Olson has worked swiftly and continuously, including over weekends, to provide documents. The only reason WFG has not had any of its documents is refused to agree to the protective order and does not include a one-way carve-out in its favor. So they're arguing right now over the protective order. They're basically saying, we're not going to send you any documents until you agree to this protective order. And WFG is saying, well, we'll sign yours, but we need a carve-out that if we find information here that we can go after other agents that have done stuff that they're not supposed to be doing. That it shouldn't just be, well, we found out the information, now we can't do anything with it. Part of getting the discovery is, okay, well, who moved over, why, what was the communication, were they spreading other misinformation out there? So Olson's team is basically saying, since they won't sign the protective order, we're not doing it. WFG is saying, well, if we can't get some stipulations on that protective order, then we're not signing it. And so that's basically what Wednesday's meeting is going to be about, is how do we actually resolve some of these things. So the discovery WFG is asking for contravenes the principles of limited discovery informing the court's order because it is broadly fishing and trying to develop claims for conduct that occurred while Mr. Olson was working for WFG and seeks to settle the Olsons with erroneous obligations based on restrictive covenant that the court has already held is not likely legal. So again, they're playing a game here with that whole California 16600. They're basically saying, well, since that's true and we should not have a non-compete clause, then whatever Olson did during the time of being with WFG doesn't really count because you're allowed to compete, and so that non-solicitation and everything else falls off. So what they're trying to say is, well, we're allowed to recruit, we're allowed to bring clients over because that's solicitation. And so even though we did solicitation, since the California rule says that you're not allowed to have a non-compete, see how they're kind of blurring the lines between the two? So they're saying, well, we don't need to turn over any documents that pertain to the solicitation because under California law, that's not legal. So they're kind of already taking the stance that they've won that argument. And so they're not going to send any documentation that shows soliciting because they've won the argument in their eyes already. So they're basically saying, well, since that, and their reason for saying that was because of the temporary restraining order. So its arguments omit key facts, which it's waiting to provide clients on the protective order until Friday night. On the date Olsons were going to provide documentations. After sitting on the Olsons versions, they proposed stipulations for 8 days. It claims that the court found that the discovery was narrow. So the court already said that all of these things are acceptable. If you remember, the judge originally said you can have discovery, but you have to limit these things. Like, we don't want to know what Olson did when he was 12 years old, right? That's like way outside of the scope. So they have to make sure it's narrowly tailored. But what Olson is saying is that they did not tailor it enough, even though the judge said it was okay. So I don't know how that argument kind of holds up, but WFG did not attach any discovery to this motion so that Mr. and Mrs. Olson could object. The court signed WFG's proposed order allowing the discovery before the Olsons were able to provide any objections. So they're objecting to it now. That's why they're not giving up any of the documents. And it claims that it needs this discovery for its preliminary injunction, while failing to acknowledge that the court found no evidence of irreparable harm, and only 2 issues exist the court mentioned already have been addressed. So they're saying there's only 2 arguments that we have to respond to in these arguments. And the first is that all documents and communications relating to the evidence of the creation of GFI and its independent contractor meeting and its registration. So they're saying they're agreeing to this, right? Yeah. So they're saying this one, WFG concedes that GFI was created in October, more than 3 months before WFG wrongfully terminated Mr. Olson. The creation of GFI, therefore, cannot have anything to do with WFG's claim that the Olsons are currently improperly soliciting WFG agents and disparaging WFG. So all of the message I get from WFG are contradictory to this exact thing, right? They're still talking to our guys. They're still saying things that are inaccurate. They're still pulling them over, and they're saying, well, because he was wrongfully terminated, first and foremost, these words are important, wrongfully terminated, so he didn't do anything wrong. It has nothing to do with the claims of improperly soliciting WFG agents and disparaging them. So they've already taken that part of the argument off the table on Olson's side. So they're saying anything that has pertained to with that, we're not helping you with. So moreover, WFG intentionally omitted GFI and its defendants in this case because it filed a duplicative claim-splitting lawsuit of GFI against Wyoming, which the judge there has stayed. Stayed means that they're not moving forward with that case until this one happens, under the first filed rule. So they're going to go through it in California. They'll take the judgment from California and then basically decide what they need to do in Wyoming. To the extent that WFG is trying to develop evidence for its suit against GFI, it should seek that discovery from GFI directly, not Mr. Olson. In any event, the discovery is not circumcised to any of these issues in court identified. That the issues the court has identified, which is interesting, right? Because they're one and the same, aren't they? Like, WFG doesn't exist without Olson, so aren't they kind of the same thing? I don't know. It's interesting. So, which is already convened, has nothing to do with the proposed solicitation or disparaging of agents, would cause Olson to conduct additional search and review, and therefore it's disproportional in its needs immediate at hand. This is especially true given the court had held that WFG's non-solicitation subject is subject to Edwards and is operating on a pleading that has not withstood the motion to dismiss. So again, just kind of goes back to that whole is non-solicitation the same as a non-compete? That's kind of where they've blurred the lines. Okay. The next part is all documents and communications relating to your use of confidential information or property, including that but not limited to its compensation structure, hierarchies, and contracts with other providers. So they're going to object to these as well. Each of these requests is overbroad because it has no limitation on time and scope, and as written, Mr. Olson has produced all the documentations, communications ever created or exchanged in his lifetime. Obviously, right? Like, he should not have to turn over every document of everything he's ever said in a text message, but within a limited scope is obviously important, right? Because it has to do with everything that's going on. So in his response, Mr. Olson limited the time period to the time after WFG wrongfully terminated him. So again, this is very important because he doesn't want everything to be seen before he was terminated. So he's trying to make the case, well, I should only have to turn over the documents after I was terminated, which is very different, right? Because what WFG wants to know, and I think what everybody on here wants to know is, well, what was said and done beforehand that got us to this point? What were you saying disparaging things? Were you lying about stuff? Or was what you were saying true and we need to know about that? So I think all of that's really, really important, but they're trying to block out those things and say, well, you know, it's not fair. It's not fair that you're asking for that. So Olson is asking to limit the search from after he was let go, which obviously you guys know what was going on before that, right? So those responses adequately capture materials related to any solicitations allegedly using confidential information or any proposed disparagement. So the reason why I think that's important for him is because let's say he went and took all of his top guys and recruited them over, and then he gets terminated, and then he doesn't talk to anybody new about it, right? Because now he's got all of these guys to go talk to all of these guys, so he can kind of use them to do what he wants to do. So he could say, well, I didn't contact anybody after I got terminated, so I didn't do anything wrong, when in actuality he was doing it previously, and then other people were kind of taking on that motion. And we've already seen that happen a couple times, because they were saying that's why they weren't on any of the Zoom calls, was because they can't officially be a part of the company till after the termination happens, after those kinds of things. So he's off the camera, but that doesn't mean he's not orchestrating things. And I think that's what WFG is trying to find out as well. So WFG argues that Mr. Olson is improperly limiting the scope. Yeah, I would agree as well. I think we should get to know back at least to when GFI was created, what was said, what happened, those kinds of things, improperly imposing a time limitation. So again, Olson's saying, well, I'll give you this stuff, but not all this other stuff, or I'll give you this time frame, but not all these other things. On the documents in response to these requests as part of a plan to use arbitrary restrictions in an effort to obstruct and delay. Its arguments are incorrect. The Olsons went to substantial length to gather and produce response documents at breakneck speed and imposed reasonable limitations that are drawn to the conduct at issue. So Olson's saying it's fair that you don't get to see anything about why GFI happened, any of his communications before being terminated. You shouldn't get to see any of that. He's saying that that's reasonably tailored. I disagree with that. I think there's a lot more than what happens, right? Like when you commit a crime, I'm not saying you committed a crime, so don't take it that way, but if you commit a crime and you go rob a bank, well, there's a lot that led up to that might be helpful information on why it happened and the way that it happened, and if there's other risks going on, right? So you wouldn't just say, well, I got caught at the robbery, so now you can have all my information after you've taken me into custody. It's like, well, that doesn't help anything. We want to know why this happened and how it happened and how it was planned and who was part of it and all that kind of stuff. So further, as noted in section 1, the only delay that has occurred was caused by WFG waiting 8 days to unveil its edits and the stipulated protective order. So again, they're saying we haven't been able to move forward because WFG won't accept our protective order. These were not delay tactics by the Olsons. Well, kind of, right? Like if I make you sign a contract that is not in your favor and you decline doing that, that's not you delaying, right? You're like setting limitations on things. So limitations are reasonable for at least 3 reasons. First, they accord the purpose of limited expedition discovery. Second, they allow the Olsons to meet their obligations without incurring unwarranted burden. And third, the Olsons of broad search terms will elicit all responsive communications regarding WFG and the parties identified in WFG's First Amendment complaint. All right, WFG's argument that it is entitled to a full-blown merits discovery is incorrect. So WFG is correct that discovery is generally broad. However, that is not the case for expedited discovery, which needs to be targeted to the issues at hand and feasibly to comply within the limited time frame allotted to complete it. The limitations imposed the Olsons serve both of these purposes. WFG claims that it is suffering an ongoing irreparable harm because the Olsons are soliciting WFG agents in violations of their obligations to use confidential information, and they are disparaging WFG in its contravention of this particular section of their employment contracts. Conduct that supposedly occurred while Mr. Olson worked for WFG is not relevant to these claims or any injunctive relief WFG would obtain. Well, obviously, like we know that all of this stuff is still happening, but they're saying that it's not. Okay, they're going to kind of go through some case law here and talk about this We Ride case. While evidence regarding Mr. Olson's conduct while at WFG could be relevant to WFG's claims and merits, it is inappropriate here for many reasons. Okay, I would love to hear this. Why is that inappropriate? First, early discovery is meant to be narrowly tailored. Okay, not to go off the merits. Okay, got it. More case law. WFG's attempt to justify its efforts to obtain complete merits discovery on its claims because of Rule 26 generally allows discovery ignores these established principles. Do you guys get that? Do you feel like WFG is asking for too much stuff? If you remember in the last one, they conceded to just through September. So September through basically, I guess, March now, end of February at that point. So they conceded on that aspect of it. They said, okay, that's fine. You're right. We don't need all these other things. Let's put September as a date and we'll gather information from there. We're not asking for the last 5 years, but they're saying that it's still not tailored enough. Expedited discovery. Second, WFG ignores that the district court has already found WFG has failed to show a likelihood of success on the merits of each claim, and that a motion to dismiss is pending amongst all of them. Granting WFG complete discovery on its claims at this stage solely on the grounds of broadly worded discovery requests is inappropriate. So to me, what this says, reading behind the lines, is we're trying to push this as close to the dismissal case as humanly possible, right? As little information as we can give them until we get to the dismissal part, because then when we get to the dismissal case, we'll go, look, they have no evidence for any of this stuff. Sure, a couple people said some things, but they have no real evidence. Well, yeah, you haven't turned anything over, right? So they're saying that it's inappropriate. Third, as described below, the burden of extending the temporal scope of the request of WFG's demands is not commensurate with the facts and the circumstances of the case. Again, right, because Olson didn't do anything wrong until he was terminated. He was terminated for no reason, and that's why you should only be looking forward to the things that he did after that, because he was just perfect upstanding citizen, never did anything wrong, and then all of a sudden you guys terminated him for no reason whatsoever. And so then if he started doing things wrong, that's the information that we'll give you, is basically what they're saying there, which I think goes against everything that the case is about. So WFG separately argues that Mr. Olson cannot impose a time limitation and must produce every existing document with any connection to its claim, no matter how tenuous or remote. I don't think that's exactly true. I think they're fibbing here as well. No, we said from September. They were willing to cut that down. WFG attempts to reframe its fishing expedition on the merits by arguing that Mr. Olson's past activity is directly relevant to the alleged future intent to continue this misconduct. Well, yeah, kind of, right? Like, if you have been sleeping around on your wife lots of times, then chances are you will continue to do so, right? Like, I don't know why that's... again, it just seems to me like they're just pushing it off. They're just trying to find anything to argue about and then not move forward. Yeah, because it is directly relevant. If you've been moving people over prior to being terminated and that's why you were terminated, well then, yeah, you're probably still doing it because nobody stopped you from doing it. That's what the temporary restraining order was supposed to help with. So anyway, and then they're complaining that that would add 50% more work. Man, those poor guys. To produce all the necessary documents, could you imagine that? Whew, 50% more work to do it all. Sorry. So silly. But that it might lead to something relevant is not warranted by the facts here and contravenes general purposes of discovery, even if it were not expedited. Olson's burden of discovery should not be doubted or doubled for many reasons. First, WFG admitted it knew the temporary restraining motion was not going to, or that the temporary restraining order was going to lose. Second, WFG failed to produce any evidence of irreparable injury in support of the motions of the temporary restraining order, which the court denied. Third, WFG offered no evidence of irreparable harm in its moving papers, nor any other reason why it entitled to broad merit-based expedition discovery. WFG acknowledges the court allowed limited discovery to Mr. Olson's due to the defendant's use of encrypted services, and alleges events are unraveling rapidly, including major conference in Hawaii. None of these concerns remain. The Hawaii conference has come and gone, and Olsons have collected and preserved all the encrypted messages. So we shouldn't have turned it over because I don't think they actually did. I don't think that actually ended up happening. But they're using that as an excuse on why they don't have to turn over the information. So fifth, in its responses to the discovery, WFG admitted that it did not have any evidence to support its claims and was instead waiting to receive documents from Mr. Olson before identifying that he had supposedly done with WFG's supposed confidential information, or what such information even was, beyond vague descriptions, confidential client information, and confidential business information. The court already ruled WFG's non-solicitation language is unforeseeable under Edwards, and further ruled WFG is not likely to succeed on claims arising from its confidential and non-disparaging provisions. Even if WFG could reach beyond the date of Mr. Olson's termination for limited purpose of its theoretical preliminary injunction motion, any purported discovery showing Mr. Olson might have violated these provisions in the past does not show that he would do so in the future. So again, kind of using that whole, they're narrowing down the time frame, saying that you can't search for this information because California says that it's not against the law. So since he didn't break the law, you can't have the information around what he did because there's nothing was wrong, right? Like they can't just gather information from you for no reason just because they feel like it. They have to have a reason. So they're kind of hanging their hat on that whole argument around the California aspect of it. 7, since the court ordered expedited discovery, the Olsons have continuously gathered and preserved documents on its electronic drives. Mr. Olson has devoted significant hours, including substantial weekends, identifying large pools of documentation, including to hold responsive material and review those documents in preparation for Mr. Olson's responsive production. Based on these substantial efforts, the Olsons have already amassed a production that could have been served on WFG on February 15th, so long the protective order was in place. Mr. Olson advised WFG 2 days prior. That work is more than proportionate to these issues here. So again, they're also hanging that hat on the protective order, that if WFG doesn't sign the protective order in the way that they want, then they're not going to turn over the documents. They're saying the search terms are reasonable. WFG did not explain why additional search terms it wanted until Friday night. Yeah, because I think WFG is kind of going, okay, if we're going to limit this for you and we're going to, give up some ground, here's some of the things that we would like search for, and then they're kind of adding to that. WFG filed for its motion to compel on Monday.